Google YouTube live Court officer.
Court officer.
ಅದು ಪ್ರಕಾಶ್ನ ಕೂರ್ಸ್ಕೊಂಡು ಮಾಡ್ಕೊಡಿ. ಪ್ರಕಾಶ್ ಹೇಳಿದ್ರು ನಾ ಕೂತ್ಕೊಂಡು ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ.
I can't grant you a stay. Dismissal order, how can I stay? Tomorrow.
My lord, if I may be permitted to mention the matter, my lord.
Going page wise, we'll have to wait.
Much obliged.
Expand. Yes.
My lord, it's page 736 serial number, plus. Appearing for R1, I have taken consent from the petitioner's counsel.
Expand.
Number 40 to 43. Page 9, number 44 to 51.
My lord, serial number 48, my lord, I appear for the petitioner. I undertake to inform the other side, my lord. My lord, we are still to receive some papers, my lord. In this matter, we have been engaged as of last week.
Please wait. I have objection. 2010 matter. Next Wednesday. I would request all of you not to seek for an adjournment in the 10-11 minutes.
Number 52, 61.
Last time, last chance.
My lord,
My lord,
serial number 48, my lord. Uh,
Same
my lord,
here.
we have much obliged, my lord.
my lord, serial number 69, my lord. Press time, my lord. Interim order may be kindly extended, my lord.
1 minute.
69.
69, my lord. Press time, my lord. Interim order may be extended.
Accurate. Proposing adjournment. Please wait. Please wait.
Number 1.
What is the regulation 22.2? You have a copy of the regulations? What is wrong with this order? They have the power, isn't it? Kindly come to page 15, the last line. You are paid 3 months pay and allowances in lieu of notice as provided under the rules. The last 2 lines of page 15. Annexure A. Who appears for FCI? Who appears for FCI? Council. Gota. Issue notice. Unit council is permitted to take out notice on the respondents through their standing council if any. Is there any counsel for the Gramina Bank? There lawyer is there. Issue notice. I want standing counsel. Shanti Bhushan take notice for R3. Is there any standing counsel? If you find out, I'll ask them to take notice. Take it up after admission. Muksumani.
Serial number 4, my lords.
delete ಮಾಡಕ್ ಹಾಕಿದಾರ?
Our by name, lords, she was made as a party. He has also filed an application for impleading, my lords, to implead the present incumbent, my lords. That application may be allowed. I filed wakalat also.
Addition of R5 is accepted. Similarly, the application filed for impleading is also allowed. Was stated to be amended.
Please.
ಮಾಡ್ತೀರಾ? The officer will complete with. ಏನಕ್ಕೆ ಬಿ ಗ್ರೂಪ್ ಹೋಗ ಏನಕ್ಕೆ ಪೋಸ್ಟ್ in the B group on. ಸಂಜೆ ಇರಬೇಕು. ಸಂಜೆ ಅಲ್ವಾ? ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಸಂಜೆ to take notice for R2. ನೀವು ಯಾರಿಗೆ ಕರ್ನಾಟಕ ಮತ್ತೆ R2 ತಗೊಳಕ್ಕಾಗಲ್ಲ ನೋಟಿಸ್. ಕರ್ನಾಟಕ takes notice for R2 and R1. Who's proposed our name? Can you not serve notice on the 9th respondent? She's working as an SDA in CMC in Elmangla. The second respondent is directed to ensure service of the application on the 9th respondent who's stated to be working as an SDA in the City Municipal Council of Elmangla.
In serial 7, I appear for the respondent, my lords.
Yes.
IA was allowed last time, amendment though, or carry out.
Weeks time to do it.
I request for 2 weeks to file additional objections.
Admit ಆಗಿದೆಯಾ?
ಇಲ್ಲ admit ಆಗಿಲ್ಲ.
B group after 2 weeks.
Much obliged.
In office objections. In office objection. ನೋಡಿದಿರ office objection ಏನು ಅಂತ? We list on 14. In the meantime, office objection is completed. What is IA 1/23? What is the agency? Rule issue ಆಗಿದೆಯಾ? Post on B group on after 2 weeks from date. Respondent here. Notice to order. Take out notice on them first. Thank If you can get him, I'll dispose it off. Also. So, under your rules, you can hold an inquiry anytime. When did he retire? 22. And the 4 years in Agilwala. Event occurred prior to 4 years. When did the event occur? What if the case is not adopted? Don't make a personal comment on him. Page. Is there any specific order which is KCSR is made applicably? They have a separate, it's a corporation. It's not a statute. It is not a statutory corporation. It's a company, isn't it? So automatically for a state-owned company, how can you apply KCSR unless the this is the general circular, isn't it? So the circular basically says conclude the inquiries immediately from no page 64 page 64 page 64 it only talks about a situation where the inquiries had to be concluded expeditiously, apart from which there's no reference to no from here, from this document. How do you say it is made applicable to the state-owned corporations? This is a general circular enumerating the procedure to be followed. From this, how can you say that the MSIL is bound by this unless they have adopted the use that? Where is the objection that they have filed saying that they have not adopted? Is the number? Which is that number? Post along with the WP number so on. Well covered in. Page. 215 ಇಲ್ವೇ ಅಲ್ಲ ಪೇಜ್. WP 13917 ತಾನೆ. We can do that. One minute to the minute. If you comply with the office objections, what are the office objections? Released on Wednesday if the office objections are not. Comply ಮಾಡಿದ್ರೆ ಮಾಡಲ್ವಾ ಅದನ್ನ ಹೇಳಿ ಫಸ್ಟ್ ಬೇಡ ಅಂದ್ರೆ. Research you're challenging. Next is Jena.
Project manager
Is this for a regular appointment or what kind of a? How can you apply the bylaws which is for regular recruitment as against notification calling for a contractual appointment? It may be a different set of
the state, there are 34 living detailers. 33 living detailers describe the qualification of being an executive.
that is the second question. It's only for a contractual employment. How can you dictate terms saying that you should adopt this qualification and that qualification? Like that. Illal litigation ಮಾಡಿದ್ರೆ ಎಷ್ಟು application. Is it a fact? Radhusri, but his contention is it's tailor made to design one individual. Objections if any. Within 2 weeks. Call on sound. Subject to the result if you want, I'll say. First, ಅವ್ರಿಗೆ ಹಾಕಲ್ಲ next week ಅಷ್ಟೊತ್ತು. Okay, 2 weeks ಹೇಳಿದೀನಿ. ನೀವೇನ ಮಾಡಿ ಅವ್ರನ್ನ. No, I'm just interested in knowing how many ಎಷ್ಟು applications ಬಂದಿದೆ, M.Tech ಅವ್ರು ಎಷ್ಟು ಜನ ಇದಾರೆ ನೋಡೋಣ ಅಂತ ಅಷ್ಟೇ. 21st. This on Friday. This will complete Friday. ಗ್ಯಾರಂಟಿನ ಇದೆ ಗ್ಯಾರಂಟಿದನ ಇದೆ ಅಂತ ಆಮೇಲೆ submitted by both the council that the issues raised in this writ petition are covered by a decision rendered by a coordinate bench of this court on 4th of July 2023 in WP number so on. Next year. In view of the said submission, this writ petition is also disposed of in the same terms. The directions contained therein shall also apply to the petitioners herein. This the matter is covered. Matter has been disposed of, has been covered. Not been necessary to comply with the officer. What is sound ilvaro? So you know, it's notice. Then R6. And DJ to take notice for R1 to R5. Put for hearing on next Monday. Amendment. ಏನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ತಿದ್ದಾರೆ? Allow the application. The application filed for amending the writ petition. Please allow the amended petition be filed. You know, ಏನ್ ಹೇಳಿ ನೀವು? When was the order? Give me the date of the order. Papers know the back wages payable to the respondent within 4 weeks. So. It becomes matter of objection. Ready. Next Wednesday. So the argument ಆಗಿತ್ತು last time. So what is there to consider? No. An application is filed seeking a direction to the second respondent to consider the representation dated 12/6/2023 for release of all service benefits. It is stated that the petitioner is suffering from health issues and is in desperate need of money. In view of the above, second respondent is directed to consider the representation on or before 2 weeks time and report complaints by released on which time you should report to the court. 2 weeks. In matter, no? Ready, na? Page. Who appears with the 10th respondent? Yes, sir. Page number? What happened afterwards? Now, this order has become final. No. Whatever be the the guidelines or notification, if this is the ultimate order to which you are a party, and if it is found that she is a resident of BT colony, then where is the finding regarding the spot inspection? This argument was advanced by you in the earlier round of litigation. Despite that, this court passed that order. Then what is it that will be done if after spot inspection, it's known that she's a resident there, notwithstanding the residence certificate, she still will have to be appointed. That is the finding of this court. Come to page 41. This was the argument that you had advanced. The finding is she was residing for the past 10 years. Now, this residence certificate was a subject matter of the earlier litigation, isn't it? Kindly come to page 41. About 5 lines from the top. The petitioner in the writ petition has produced certificate of residence of the 10th respondent, which shows the 10th respondent is a resident of Nagar East, Kasba Hobli, Kolar Taluk, which is not being in BT colony. What is the inspection that the authorities carried out after rejecting the objections is not made known, and what basis decision has been taken. So once again, they have conducted spot inspection and it has been accepted. And how can I go into that now? She's been working now for 3 years. But in is physically handicapped. Chalo ready. Nineteen. What number? Page number 19. No, but how can I get over this finding of fact that she is a resident of BD colony, which has been carried out pursuant to this order? And you're not questioning this finding. You're again coming back with the same argument that you advanced in the earlier round. What is there to show that no spot inspection is conducted apart from read annexure L. ಗಳನ್ನು ಪೂರೈಸಿದ್ದೇನೆ. You cannot go beyond that order. You and I are both bound by that order. The petitioner had challenged the appointment of 10th respondent as an Anganwadi worker in WP 13055 for 2018. This petition was heard along with several other petitions, and ultimately this court, while allowing the petitions, issued the following directions. Page 44. It may be pertinent to state here that the argument advanced in that writ petition was that the 10th respondent had produced a certificate which indicated that she was a resident of Ramat Nagar East and therefore could not be considered as a resident of BD colony. This court, in the light of the assertions made in that writ petition, passed the above mentioned order directing a spot inspection to be conducted and a determination be made as to whether the 10th respondent was a resident of BD colony. Next point. Pursuant to the order of the learned, pursuant to the said order, a spot inspection was conducted and a report was obtained, which was to the effect that the 10th respondent was indeed a resident of Farida colony for the past 10 years. The relevant finding is reproduced here in page 63. In the light of this finding, it is obvious that the petitioner has been unable to establish. In light of this reasoning, it is clear the 10th respondent is in fact a resident of BD colony and therefore was entitled to be appointed. Learned counsel for the petitioner, however, submits that there are documents which indicate that she is actually a resident of Ramat Nagar. It is to be stated here that when a spot inspection was conducted and it was found that the 10th respondent was indeed a resident of BD colony for more than 10 years, the argument of learned counsel that the documents speak otherwise cannot be accepted. I find no reason to retain the repetition and the repetition is therefore dismissed. Review. That review of the order. The petitioner has filed a memo stating that at present there is no threat of displacement for the petitioner and hence he may be going to withdraw the petition. So he also seeks liberty to approach this court in the event he is displaced. In the light of the above memo, writ petition is dismissed as withdrawn, reserving liberty to the petitioner to approach the court if the occasion so arises. What is a prayer? What is annexure K? The village accountant civil post illiಗೆ ಬರುತ್ತಾ CAT ಗೆ ಹೋಗುತ್ತೆ PAT ಗೆ ಹೋಗುತ್ತೆ. Right, under 226 there's a bar. If wherever a state administrative tribunal has been constituted in the matters of public employment and if recruitment is also a service matter, therefore you may have to approach the state administrative tribunal. I would have no jurisdiction at all to entertain this, since the grievance of the petitioner pertains to recruitment as a village accountant, you would have to approach the Karnataka State Administrative Tribunal and not by way of this writ petition. Writ petition is therefore dismissed, reserving liberty to the petitioner to approach the Karnataka State Administrative Tribunal. The deserter. Take out notice on them. Who appears for respondents? Central Government Standing Council. She is also to take notice for respondents. Released on 2 weeks on the date. What is the order that they have said? You've been declared as a deserter. Then what next? I'll have this matter next week. You get him and then we will see, because this is an order passed in the year 2021. We are now in 23. Take notice on him, let us see. Released on. The notice. And council is permitted to take out notice on Rakshita correspondence. Released on. Ready na?
Lords, insofar as this matter, Lords,
ನೀವು ಯಾರಿಗೆ? ನೀವು ಯಾರು ಶ್ರೀಕಾಂತ್?
Lords, for the second respondent, my lords, Lords, appears to be, my lords, covered by early editions of this code. Lords, how do you get instructions, my lords, in the matter, my lords? Have
These matters are disposed of. Which have been interim stay. All for the proceedings. Same order, huh? Pursuant to annexure A. Since it is stated that by annexure V, W and X in respect of similarly situated employees, there is already an interim order. Post along with WP number 10558/2018, WP 12690/2019 and WP 18837/2019. A and B. Recovery ಆಗೋಗಿದ್ಯಾ? You notice. Tender should take notice for respondents 2 to 4. Rakshita for R1 APTC level. Let's come here. Improve on the Here, they stated that the writ petition pertains to cooperative societies. Post before the appropriate. Good for the respondent. And then the person will take notice for respondent. Released in the pay group. ನೀವು ತೊಗೊಳ್ಳಿ ನೀವು ಕಳಿಸಿ ಅವರು ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ.
Appear for petitioner. Because petitioner was dismissed from the service on 16/5/2023. He was the second division clerk, my lords, in the Hopcoms.
ಡಿಸ್ಪ್ಯೂಟ್ ರೈಸ್ ಮಾಡ್ಲಿಲ್ವಾ? ಡಿಸ್ಪ್ಯೂಟ್ ರೈಸ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
My lords,
ಕೆಳಗಡೆ.
no, my lords. It will come before this court only.
ಇಲ್ಲ ಇವರ ಸೊಸೈಟಿ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ತಾನೆ?
ಇಲ್ಲ, Hopcoms.
Upcomes is still a cooperative society, isn't it?
No, my lords. The service and all have to challenge before this court.
ಅಲ್ಲ ಅದು ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ತಾನೆ? Then I'm sure you'll have to go before the ARCS. Take out notice on the petition.
Yes.
Then a DG take notice for R1 to R3. OPS or Upcomes? ಗೊತ್ತಾ ನಿಮ್ಗೆ ಯಾರು ಲಾಯರ್ ಅಂತ?
I'll take out notice for my lords who will appear for the Hopcoms.
ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಇದೇ ತರ. She notice. Post number. This is number 2. Yeah, acknowledgement. Next year. ಇಲ್ಲಿದೆ ಇದರಲ್ಲಿ. ನಾನು ರೆಕಾರ್ಡ್ have seen. ಒರಿಜಿನಲ್ ಇದು ಫಸ್ಟ್ ಅವ್ರು ಬಂದು ಅಪಿಯರ್ ಆದ್ರಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಸಿ ಒರಿಜಿನಲ್ ತೋರಿಸಿ ನಿಮ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಯಾರು ಬಂದಿಲ್ವಾ ನಿಮ್ ಬ್ಯಾಂಕ್ ನಿಮ್ ಆಫೀಸ್ ಯಾರು ಬಂದಿಲ್ವಾ? ಪ್ಲೀಸ್ ನೀವ್ಯಾರು ಕೇಳ್ಕೊಬೇಕು ತಾನೆ ಎಲ್ಲಿದೆ ರೆಕಾರ್ಡ್ ಅಂತ. ನೋಡ್ತಾನೆ ನೋಡಿ. This file is not pertaining to that particular period. This is only till February 2006. This dispute arose only in the month of May 2006. ಅದಾದ್ಮೇಲೆ ಯಾವುದು ಇಲ್ಲ. Then I'll accept whatever he has said to be the truth. No 1 week. This is not something where you can take. You have made a submission that the records were in Kolar. Now you are able to secure the records from Kolar. I'll ask the GM to be present. Maybe that will be the solution to this. ಬಂದಿದಾರಾ ಇವರು? AGM ಬಂದಿದಾರಾ? When the writ petition was filed, this AGM was aware of the fact that the case is pending. Therefore, you should keep the records. On what basis did you prepare the objections? Where is that record? The record that you're now producing relates up to February 2006. After 2006, you're deliberately keeping away the records from the court. So I'll direct the GM to be present. Your conduct echo is not inspiring confidence in me, the way your bank is behaving in this case. Mr. Counsel, what is the submission you're making? You have filed objections. If they don't have the records, you come and throw some record pertaining to some other period, saying this is all the record that you have. I'll accept the statement and proceed to pass orders. ಈಗ ತುಂಬಾ ಕ್ಯಾಶುಯಲ್ ಆಗಿ ತಗೊಳ್ತಾ ಇದ್ರಿ ನೀವು. ಎರಡನೇ ಸಲ ಇದು. ಹೋದ ಸಲ ಒಂದ್ ಲೆಟರ್ ಬಂದು ಬಿಸಾಕಿದ್ರಿ 4 weeks ಕೊಡಿ ಅಂತ. For a bank, can you give all these reasons? 4 ವಾರ ಬೇಕಿದ್ದು ಒಂದಿನಲ್ಲಿ ಬರ್ಲಿಲ್ವ ಫೈಲ್? ಹಾಗೆ GM ಬರಂಗ್ ಮಾಡಿದ್ರೆ ನಾನು ಅವಾಗ ತಕ್ಷಣ ಸಿಗುತ್ತೆ. I'm warning you for the last time. You're testing my patience unnecessarily in this case. Relist on Wednesday. list on Thursday. Council to produce the relevant records pertaining to the relevant period. So if the records are not produced, the AGM to be personally present before the court. Last chance, I'm warning you. Biophysics. Biophysics. Yeah. Both the cadres are equivalent, lecturer and assistant professor. Yes. No, but annexure B says both of them are the same, isn't it? Lecturer and assistant professor are the same. Then where is the question of promotion on 18th of September 2007? Then what happened after this? You are the holder of an MSc. ಯಾವ್ದ್ರಲ್ಲ ಎಲ್ಲಿ ಓದ್ತಿರೋದು ನೀವು? Document number? This is in respect of 5/2/2020 communication. Memo is dated 5/8/23. No, last time when it was argued, as on the date of your appointment on 21/5/2007, what did the C&R rules stipulate for promotion? Yes. What were the regulations in force as on that date? Page number? No, you were appointed as a lecturer. That is column number C or column C? No, but even for being appointed as a lecturer, did you require a PhD according to these regulations? So therefore, are there separate qualifications prescribed for this college? Did they have their own? No, or else is this qualification read disjunctively? MD biophysics or MSc biochemistry. That is one thing. Or in case you have a medical biochemistry, then you require PhD with biophysics or MD physiology or MD biochemistry with 1 year. Is it the way it should be read? Katie? Because that or if it is read disjunctively and this portion is read independently, then it means people who have medical biochemistry as a master's, they should have a PhD and not the people with MD biophysics. There is no reason for. Would that be the correct way, Mr. Katie? Because I don't understand why the word or should be placed in this particular position. This indicates that only people having medical biochemistry with PhD, only for people with medical biochemistry master's degree, they require a PhD. That's what it says. MD biophysics / MSc biochemistry. So it can No, that's what I'm saying. If he, suppose, no, suppose there are two alternatives. One is either an MD biophysics or an MSc biochemistry. That is good enough. Or in the event you have an MSc or an MD in medical biochemistry, then the requirement of this PhD with biophysics becomes important, because a master's in biophysics by itself is sufficient. Whereas a master's in biochemistry would require an additional study of biophysics. That's why they require a PhD in biophysics. If you have taken a specialization only in biophysics, you don't require a PhD. Then he'll be eligible for promotion to an assistant professor, sorry, associate professor, and also to a professor. If that is the way the rule is interpreted. And that appears to be the reason why he has been appointed, because he held a master's degree in biophysics. MD biophysics, he said. MSc biophysics. Huh? That is sufficient. Then he requires, then he got a bio. No. The first column is MD biophysics. If he has a master's degree in biophysics, there's no question of needing a PhD. It's only if you have a master's degree in medical biochemistry, you require a PhD. That would be the way to read this particular regulation. Or else there's no reason for that all to come there. They are considering both of them are the same. MD in biophysics and MSc in biophysics. They are equivalent. The next one is if you have medical biochemistry, then you require a PhD in biophysics. Because if this is MSc, the next word MSc. Correct. So therefore they use both an MD biophysics and an MSc biophysics, whether it's medical biophysics or non-medical biophysics. If they have a master's degree, that's it.
Not required a PhD.
No. This PhD is to be read in conjunction with the people who have a master's in medical biochemistry. That is all, because that makes sense. A person with medical biochemistry may need to learn more about biophysics, whereas a person who studied only biophysics and got a master's, he doesn't have to go through this.
Actually, the other way around, but anyway, that's not the report of this. Here it is biophysics. / MD and MSc, the two options. One is biophysics or medical biochemistry. You would have an MSc.
Then they have put this or on top. They have said MD biophysics, that is a medical education. Then or. Then you require, if you don't have a medical education, then you have a non-medical education, you require a PhD too.
This is actually but all of them.
Yes.
Whichever we are both.
So if my understanding is correct, if a person has a master's of science in biophysics, he becomes eligible for all the posts without having the need to have a PhD.
Just having an MSc. Get a higher. We get a higher. As far as MSc is concerned, because they need to have biophysics in the context of medical education. Therefore, why they put that together is even other MScs are also accepted. However, later you will need a PhD in these degrees because they widened it. Said
See this once again. No, MD biophysics. If he has that, is eligible. Now next is MSc biophysics. He has that. Now the third one is medical biochemistry with PhD or MD physiology. Or if you assume this slash is again different, the third one is a person who has an MD physiology or an MD biochemistry with 1 year training in biophysics. So there are 4 qualifications prescribed. One is either an MD biophysics or an MSc biochemistry. The third is medical biochemistry with PhD or medical MD physiology or MD biochemistry. These are the 4 requirements. If he qualifies with any one of them, he becomes eligible to hold all the 4 posts. Now, if you're going to use this disjunctively or conjunctively, according to your convenience, you can give a kind of very different meanings every time you read it. You can apply this PhD to anything. You can apply this PhD to an MD in biophysics also. Isn't it? If you're going to apply this or because I don't want to go by his argument about other people having been. Because if my understanding is the right understanding, then it has a larger ramification.
We are urging and it will remain the same. Nonetheless, I will. This is the one which has identical wording of each qualification, each discipline.
I am splitting it into 3 parts. One is MD biophysics or MSc biophysics. First one. Second one is medical biochemistry with PhD. Or the third one is with PhD biophysics or MD physiology or MD biochemistry with 1 year training. 3 portions. One is MD biophysics or MSc biochemistry. That is a first qualification. Second one would be medical biochemistry with PhD or MD physiology. Then the third requirement is MD biochemistry with 1 year training. This, according to me, would be the correct way of interpreting this regulation. If you have this first 2, you don't need anything else. You either have an MD biophysics or an MSc biophysics, they're in matter. In case you have medical biochemistry, a master's degree, then this equivalent having a PhD in biophysics or a medical physiology, medical degree. Then the third one is, if you have an MD in biochemistry, you require 1 year training in biophysics. The distinction that I'm seeing is in the first. Yeah, that is because the first portion deals directly with biophysics. Yes, that is what I'm thinking is the, because for me it makes sense because the first qualification is directly on biophysics. So he doesn't have to need anything else. The other master's degree are in maybe sister subjects, which may help them do a biophysics, but they become eligible because of an additional degree that they have in biophysics. That's my thinking. Well, this is generally for all the posts, but when you are referring to a specific appointment as lecturer in biochemistry and you prescribe a specific qualification in biophysics, how can you apply this general condition? I think, when do you want it? Next Monday. Our ಹೇಳ್ಬೇಕಲ್ಲ ಇರ್ರಿ. They are the supreme body. If KT says it, he is the final word in terms of qualifications. What is this matter about? Accounts. Mr. Arnoldi argued that matter. How can the accountant general I thought that was a bit dangerous, asking the accountant general to sit in judgment over the selection made by a committee, declaration of probation. 10 years thereafter, if they say. No, but they are required to audit this accounts in the light of the statutory provisions under the act. They only have to make an observation. Ultimately, for the chancellor to take a call if there's something wrong. But to say that this is the mode of selection that you ought to have. Next one. Next one. Vidya, intermodal to continue in there. Prima facie, as of today, I am prepared to allow the writ petition because Vikram came and asked for time, granting time. I think I should hold you responsible. You appointed them, isn't it? ನೀವು 10 ವರ್ಷ ಕೆಲಸ ತಗೊಂಡು ಡಿಕ್ಲರೇಷನ್ ಮಾಡ್ಬಿಟ್ಟು how can you say that the AG is you should be fighting for their cause rather than anybody else? It's your responsibility having appointed them. You're not washing your hands off now by saying that government ನೀವು ತಾನೇ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದ ಮತ್ತೆ it's not fair on your part. I thought you should stand up and fight for the selection that you had done. You're now falling back upon the AGs to get rid of them after 10 years. Expanding. Information ಬೇಡ ಬಿಡಿ. ಅವರು ನಿಮ್ ಜೊತೆ ಆಟ ಆಡ್ತಿದಾರೆ ಅವರು ಯೂನಿವರ್ಸಿಟಿ ಅವರು. Maybe you did not take care of them well. That's the reason why. What issue? In what annexure, this validity of annexure A is before the division bench. Challenging annexure A, isn't it? What is? Let us read annexure A first, then you'll understand. ಎಲ್ಲಿ ಓದ್ತಿದ್ರ? ಎಸ್ ಟೈಪ್ ಕಾಪಿನ ಇದು? This was the act that you just now read. No, the amendment you just now read out was in relation to act number. Page 132 ಓದಿದ್ರಲ್ಲ, is it the same act 4 of 2015? By bringing the amendment bill act for ಈ ವಾಟರ್ ಮೇಲೆ ಅಪೀಲ್ ಇದೆಯಾ? ಈ ವಾಟರ್ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ. Take this also an appeal. No, I will simply follow this order and ask them to challenge it if you want to file an appeal. The very same question has gone into by a coordinate bench. Or else I'll dispose this of subject to the result that may be made in the writ appeal. Even if I pass an order now, allowing the writ petition in the same terms, they'll once again file an appeal and the same problem. That I can't go into now. I'll just follow this statement and anyhow they have filed a writ appeal. That should have been a ground for you to urge and we should have got that writ appeal dismissed. Same, I'll allow it in the same terms. Appeal case. ಎಲ್ಲ ಕೊಡಿ ಎಲ್ಲ ಅಲೋ ಮಾಡ್ತೀನಿ, you can challenge it in an appeal. You already suffered a direction. I'm not the first one to issue a direction. There can't be one set of relief to one set of teachers and a different set of relief to a different set of teachers. ಅಲ್ಲೇ ಹಾಕ್ಬಿಡಿ ಅಪೀಲ್ ಹಾಕ್ಬಿಡಿ, ಆಮೇಲೆ ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಅಂದ್ರೆ ಅಲೋ ಆಯ್ತು ಅಂದ್ರೆ ಅವ್ರನ್ನ ಕೇಳಿದ್ರೆ ಮಾಡ್ಬಿಡ್ತಿರಲ್ಲ. They will not even be heard in the matter. Mr. I am arguing for your behalf. I'll allow this, you file an appeal. ಒಂದು ಮುಂದಕ್ಕೆ ಸ್ಟೆಪ್ ಹೋಗೋಣ, ಇಲ್ಲ ಅಲ್ಲೇ ಕೊಡಿ ಲಿಸ್ಟ್ ಕೊಡಿ, ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. ಕಾಮನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತೀನಿ, ಎಲ್ಲಾದ್ರೂ ಲಿಸ್ಟ್ ಕೊಡಿ. Next week I'll allow all the writ petitions. Give me the list so that at least ಅವ್ರು ಹೇಳ್ದಂಗೆ ಇನ್ನೊಂದು 5 ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇಟ್ರೆ ಹಂಗೆ ಹೋಗುತ್ತೆ, ಮುದೋಗುತ್ತೆ ಅಲ್ವಾ? ಅಲ್ಲ, ಒಂದ್ ಇನ್ಕ್ರಿಮೆಂಟ್ ಅಂದ್ರೆ ಸಿಕ್ಕಾಪಟ್ಟೆ ಕಾಸು, ಬಟ್ ಓವರ್ ಎ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್ ಇಟ್ ಅಮೌಂಟ್ ಸಬ್ಸ್ಟೆನ್ಷಿಯಲ್ ಅಮೌಂಟ್ ಸುಮಾರು ಬರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಲಿಸ್ಟ್ ಕೊಡ್ತೀರಾ? 18th auspicious day, na? For what? For following ಏನಕ್ಕೆ? I just want you to, you have the number, similar numbers there ಕೊಡಿ, ಅವ್ರು ಯಾಕೆ ತೊಂದ್ರೆ ಕೊಡೋದು? I cannot preclude the writ appeal by saying that division bench already taken the view. Therefore, this writ appeal should also. Can I say that the writ appeal will say that? Why should I? So you want me to hint, give them a hint saying that agle released on. You can give me the list. I'll have all the matters on Monday. Released on Monday. Then at AGA to furnish the list of similar matters pending before this court by then 16th. Or vacating stack ಇರೋದು ಇಲ್ಲಿದಾರ? Yes. What is a prayer? Next year, F. You're challenging an you're challenging an order by which you're being relieved. No, you're challenging that. No, you're challenging an order by which you're relieved. Where is your appointment order? Next year? F. Yes. There are no regulations for governing the recruitment to this. This institute is society. What is
Technology was founded by or supported by. Here is the technology IIT Mumbai it was instituted and they were doubting more or less the day it could stand on its own.
no? Is that Indian technology a society registered under the Societies Act? What is the entity? Legal entity. What is a legal entity? IIT, is it a corporation? What exactly is? How was it constituted? Which? This is governed by an act. So the recruitment also should be governed by the statutes framed under the act. What are the statutory regulations framed under the act in respect of recruitment? Act only, Lakshman. Indian Institute of Technology Act. Institute of Technology Act. No. You have a copy of the statutes that have been framed under section 26 of the act. Lakshman. The act to hakidra, act to statutes scheme halakide. Section 25 says all appointments on the staff of any institute, except that of the director, shall be made in accordance with the procedure laid down in the statutes by either the board or by the director in any other case. Equal to which clause, which statute is referable to this appointment? No, that should be referable to some statutes, alva. What is the post that you're holding? One minute. Which is a statute which provides for temporary appointment? It's regulation 19. You are a temporary employee. Because, no, kindly see. The next area on the offer of appointment. Mode. Yes, page 18. Where is the provision, Mr. Murthy, for appointing somebody temporarily and thereafter regularizing them on assessment? There are three categories of posts. There are three classification as per this regulation 19. There shall be the following categories of employees of the institute: permanent, temporary, and employees on contract. Schedule B.
Temporary employees. Temporary employees.
Now, this talks about the third clause. It talks about notwithstanding anything contained in these schedules. The board may, in special circumstances, appoint an eminent person on contract for a period not exceeding 5 years, with a provision of renewal for further period, provided that every such appointment and terms thereof subject to the prior approval of the visitor. So that is not a clause that is incorporated in the order of appointment. Therefore, it is not a contract on. If there is a temporary appointment, if you promise them regularization, then what is the effect? It's not really a temporary appointment. Temporary appointment should indicate the tenure is only for so much, and you have no right for the, let's say, for the entire service tenure of yours. But it does not stop there, isn't it? That is the problem. I shared it, then I'll fall back upon schedule B. But this goes on to say something more. It says is initially temporary for a period of 3 years and may be regularized through a process of assessment subject to the minimum eligibility criteria for the post being met. So therefore, this was not an appointment that you made strictly in accordance with the regulations. This was something of an hybrid appointment. It was temporary. At the same time, you could also regularize it and make it a permanent appointment.
Assessment of the work, which is called as
This process of assessment that you have prescribed in the order of appointment is not forthcoming in the statutes. So therefore, you evolved a new procedure for appointing a person temporarily for a period of 3 years and thereafter deciding to assess his suitability for regularization.
taking for 3 years. You can apply self-assessment for faculty for grade 2 to grade 1 membership. That is what submitted. Why is he submitted? On both the application, the expert committee is making reviews. How that it was not self-assessment. And it would not be taken from grade 1. You will not get that at grade 9. grade one or grade two.
If he is not suitable to go to grade 1,
Yes.
then he can continue in grade 2.
He is grade two.
Then why, how are you relieving him now? How are you relieving him now? He sought for an upgradation of his post to grade 1. The expert committee, let's assume, said he is not good enough. But how can you now throw him out from grade 2? Where is the power for you to restrict it to 3 years under the statutes? ನೀವೇನೋ ಹೊಸ ಪ್ರೊಸೀಜರ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ನಿಮ್ಮಷ್ಟು ನೀವೇ. This is not forthcoming. It gives an indication that you are on trial for 3 years. Then we will assess whether you should be regularized or not. That is not what the statutes contemplate. You can.
If you submit your self-assessment.
No, that should be found in your statutes. Such kind of a procedure should be found in a statute. You are now depriving a person. You keep on doing this for 3 years, every 3 years. You will never do a regular recruitment then.
Which is a permanent post.
Like,
But otherwise, I should say, who are sharing around, correct the property number. Then all the temporary.
ನೀವು first regular recruitment ಮಾಡಬೇಕು. If he is not fit, don't take him. But once you take him in, then you put him on a tent rooks, always saying 3 years ashte, 3 years adme let us see. Then what is the point? And I can understand if that is a power that is available to you under the statutes. There is no other provision in the regulations which permit. Now, there is no other clause in the regulation which permits such kind of regularization or continuation after this initial tenure is over. Because this clause 2 of schedule B simply says after the period of temporary appointment is over, give him 1 month notice and he is out.
Yes, not only for 3 years, then some period. If I ask you to know, where will I get right people? Whatever shall be mentors that we have. Okay, who shall?
ಅದು ಎಕ್ಸಿಟ್ ಮಾಡಿದೆ ಯಾರು ಬೇರೆ
ನಾನು ಹಿಂದ್ಗಡೆ ಓಡ್ ಬಂದೆ.
ಎಲ್ಲ ಬರ್ತದೆ. ಇದು ಎಷ್ಟೇದು ಅಂತ ನೋಡ್ಬೇಕು ಅದಕ್ಕೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋದ್ನ ಎಕ್ಸಿಟ್ ಆಗ್ಬಿಡು.
Exactly after 3 years you were asked for. This wording is kind of very, very vague. The appointment is initially temporary for a period of 3 years and may be regularized subject to the minimum eligibility criteria for the post being met. So he does possess the eligibility criteria. Then you're talking about a process of assessment, which is not been prescribed either on the statutes or under any other mechanism by which he knows what is the level that he has to come up to. Then you're virtually keeping him in the dark and you decide what is the mode of assessment, whether he passed the test of assessment. ಅಲ್ಲ ಅವನಿಗೆ ಕೆಲಸ ಕೊಟ್ಟಾಗ ನೀನ್ 3 ವರ್ಷ ನೋಡ್ತೀವಪ್ಪ, ನೀನ್ ಈ ತರ ಅಸೆಸ್ ಮಾಡ್ತೀವಿ.
Information given to those people who have been taken as assistant. Unlike that is already like the end of the term. An option is given, an opportunity is given for him to become assistant professor grade 1. If he passes through that as that emphasis for
So you're now,
grade 1 that much.
so you're now offering a temporary employee the chance of securing a permanent employment. Whether that kind of a process is permitted under the statutes. How can you ignore the statutes? If there's any power to relax it, that is one thing. You decide whatever you want to decide in the light of the statutes. Would that be permissible? Then why have the statute at all if you want to make your own regulations, your own procedures? So you're finding you're kind of finding a new kind of category. Temporary but can be made permanent. No, but at the statute illidre ನೀವು how can you adopt that procedure? That unless that is reflected in the statute, there is going to be a problem. Because he will definitely say that this is an order of permanent appointment. This particular clause that you have incorporated in the offer of appointment is illegal and not backed by statute. Therefore, you cannot rely upon that to relieve me. No, not me, his argument. What if I accept the view is what I'm thinking. ನಾನು ಇನ್ನೊಂದು ವ್ಯೂ ತಗೊಂಡ್ರೆ ಒಂದ್ಸಲ ತಗೊಂಡ್ರೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ if has gone through the correct process of selection as prescribed under the statutes, then it's a regular appointment.
Regular appointment. It is also regular appointment and promotion. What? Professor grade 1, assistant professor grade 2, assistant professor grade 1 is a promotion.
So therefore you are assuming he is a permanent employee in grade 2. For him to be considered as promotion to grade 1. He can be promoted to grade 1 only if he is a permanent employee. Therefore, even then, this particular clause can't be relatable to a temporary appointment. The fact that you're considering promoting a temporary employee to a permanent post indicates it's a permanent post, not a temporary appointment.
It is not that it is going to be decorate that it is going to
Well, that's but the base one alone, that is permanent. ನೀವು ಅದನ್ನ ನಿಮ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ಸ್ ಆತರ ಪ್ರಾವಿಷನ್ ಮಾಡ್ಕೋಬೇಕು ತಾನೆ. ನೀವು ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಇದ್ದಾಗ ಐ ವಿಲ್ ಡಿಸ್ರಿಗಾರ್ಡ್ ಇಟ್ ಆರ್ ಐ ಅಪ್ಲೈ ಇಟ್ ವೆನೆವರ್ ಐ ವಾಂಟ್ ಇಟ್ or I will disregard whenever I don't want it ಅನ್ನೋದು ತಪ್ಪಾಗಲ್ವಾ? You are an institute of excellence. How can you decide for yourself unless you have given the autonomy under the statutes to take a procedure which you think is appropriate in a given case? If I accept this contention that this clause on the basis of which is been relieved is not backed by a statutory power and is therefore to be ignored, then he becomes a permanent employee as an assistant professor grade 2. Then remove him in any manner that you think proper in accordance with the statutes. But you cannot use this clause.
The rules of having this contractual appointment will itself get negated.
No. If you were to fall under clause C and say it's a contractual employment, that clause should indicate 5 years with a right of renewal or a possibility of renewal. Then he knows it's a contractual. Temporary andre he knows he doesn't get anything further than that period. But ನೀವು ಇತ್ ಕಡೆ ನಿಲ್ಲ ಅತ್ ಕಡೆ ನಿಲ್ಲ ಆ ತರ ಮಧ್ಯದಲ್ಲಿ ಅವನ್ನ ತ್ರಿಶಂಕು ಸ್ವರ್ಗ ಮಾಡಿದ್ರೆ page 18. Yes.
The appointment is initially temporary for a period of 3 years and may be regularized to a process of assessment subject to the minimum eligibility criteria for the whole treatment. It is terminable by giving a writing once the certificate set without eligibility. It goes on. Right. So I said, I have no privacy. Initially, temporary process of assessment is released.
This, if you can point out a particular clause in your statute which gives you the power to put such kind of a condition, I'll say that he is bound to be relieved because it is bound by statute. If your statute says one thing and you do something else, then
The number of candidates
next Monday. Okay. Who's opposing you? Who appears for BBMP and Lokayukta? ನೀವು ಯಾರಿಗೆ ಅರ್ಬಟಿ ಅವ್ರಿಗ Have you served a copy on the government, state government? What is your instruction? Signature ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ನಿಮ್ಮ ಕಾಸಲ್ಲೇ ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಡಿ. List on so and so. Copies be furnished to the council appearing for the state and for the fourth respondent. Office is there to show the name of the AG as appearing for the state first respondent. Next Monday. On copy ಕೊಟ್ಬಿಡಿ ಅವಾಗ next time ತಿರ್ಗಾ time ತೊಗೊಳ್ಳೋದು ತಪ್ಪುತ್ತೆ. ನೀವು ಯಾವ ಡೇಟ್ ಬೇಕೋ ತಗೊಳ್ಳಿ. 17. What was the original order that you challenged in this WP 19572/2015? What was the order that you challenged? The order of compulsory retirement. Where have they said that? No, was the order of the learned single judge set aside? No, in that joint compromise memo, was the order of the learned single judge set aside? Then would it not be entitled to the benefits there? That is a consequence of being reinstated. So let us see the order of the learned single judge as it stood before it went in appeal. That is at page 18, isn't it? No, one by one. You please wait for a minute. An order of compulsory retirement was passed. That was challenged by him. That ended in the order which is extracted at page 18. Please read page 18. Yes. No, you just read the extracted portion. Therefore, so 1 minute, stop there. The order of compulsory retirement is therefore set aside. Correct? Now, therefore, this court sets aside the impugned order and the punishment order. This court substitutes the punishment with the punishment of withholding of 3 increments with cumulative effect. So this is the ultimate punishment. 3 increments with cumulative effect. This court further directs the respondent to reinstate the petitioner and to grant continuity of service. So it's like as if he has never been removed. He is continued in service, but with the punishment of 3 increments, and directs them to pay 50% back wages. The compromise that was entered into was only in respect of this back wages. So every other portion of the order of the single judge stays. Please read that, para one.
Expected portion of the staff. The respondent is- Respondent has a weakness. First, this is not-
So the only modification was instead of 50% back wages, 25%. And whatever else was granted. This is not on the basis of his joint memo. The order of learned single judge granting him continuity of service was not set aside by the joint memo.
He was reinstated.
This for the back wages. Continuity of service by virtue of the fact that the order of compensation was set aside. He is deemed to have continued in service. So whatever benefits accrues to him as being in service, if there is a promotion that he was entitled to, then what is the meaning of continuity in service? You tell me the basic meaning of continuity in service, especially when an order of dismissal has been set aside. But I agree with you that if he is eligible for a promotion on reinstatement, he'll have to be given that. When did he become due for a promotion? What was his designation when you terminated him? Staff officer. What were you appointed as? Lala. What were you appointed as? Appointed as sub-staff. Yavaga? From sub-staff to clerical. When was that? 85. 95. Staff officer. What was your next promotion due? Middle management to MM2. One nimisham, let me. Middle management to. When did you become eligible according to you? You took the exams and all that. No, after you pass the examination. Is that the fact that he passed the competitive examination and because he says he passed the examination successfully, he also appeared for the interview.
These are two things that are brought up again.
When did you terminate him? When did you terminate him?
Each person.
No, 2008 if he's terminated, how can you allow him to take up the exam? No. 2008 terminated, 2012 reinstated. How were you reinstated? Joint memo. So you have decided to give him a hard time. Decided to give him a hard time from the beginning. 2012 you were reinstated. You took the exam in 2013. When was this offer of order of compulsory retirement passed? Alala. Compulsory retirement order agide yavaga. Compulsory retirement when was the order passed? No, because you filed a petition in 2015 challenging the order of compulsory retirement. 6/6/2013. 6/6/2013 is compulsory retirement. This was set aside in 3/7/2015. Then he'll be eligible. If he has taken the exam on being reinstated on 6/6/2013, if he is successful, if he has undergone an interview. Have you rejected his claim for promotion? Have you rejected his claim for promotion after he passed the examination? 3,000. The moment you reinstated him on 6/6/2013, then he became entitled to seek for a promotion. He sought for a promotion. He was required to take an exam. He was required to appear for an interview. If he has done both, and if you have rejected the promotion, claim for promotion, then you have something. This is the only argument that he can have. It's continuing in service, isn't it? You should have rejected his claim for promotion pursuant to that process. If it has succeed adre. Promoted as what? Promoted as what? If he is entitled to be promoted to this mid-level management too, if he has passed exams twice, if you have list on 14 by the next date of hearing, the counsel for the bank to state the outcome of the claim of the petitioner's promotion that he made for the post of mid-level management 2 in the year 2013 and 2017, since it is contended by the party in person that he had successfully passed the necessary examinations and also appeared for the interview pursuant thereto. 17. If you don't get insects next time, you make him come up and down again, you'll have to pay the costs. If you want to take time before that, inform him so that he doesn't have to come all the way from. SLP pending ಇದೆ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ ಲಾಸ್ಟ್ ಟೈಮ್. SLP pending ಇದೆ ಅಂತ ಆಗಿದೆ. What are you selling annexure G? Petition that you had filed had been dismissed. The petition that you had filed, challenging the show cause notice was dismissed. Where is that order? Because you no longer are in service, there is no question of dismissal. No, were you in service? Had you not retired? Then the next, this thing, in all other matters where the petitioners were dismissed from service, the action of the respondent authorities and orders of dismissal are upheld. So therefore, people who had been issued a show cause notice and were in service, show cause notice is upheld. So even though you lost in the battle, even though you lose in the battle, you still win the war. Really, your challenge to the show. I think you should await the decision of the Supreme Court. All benefits Is that a fact? Is it a fact that you have given terminal benefits? In what way were they different? Now, in this case, you had only issued a show cause notice. There was no formal order of termination. So if there's no formal order of termination, then what is the effect? He has continued in service, attained age of superannuation. Unless you pass a specific order stating that the order of appointment was bad, and therefore you are not entitled, you are dismissed from service with effect from that particular date, then you may withhold his benefits. If no order of termination is passed, and if you have allowed him to superannuate, did you reserve the right to terminate him? Did you, when you allowed him to superannuate, did you reserve that right? Correct. So you cannot terminate him. But when you allowed him to attain the age of superannuation, did you say it would be subject to the result of the writ petition or subject to your right to take action against him? Yes. Stop there for a minute. So in respect of those employees who are continuing in services, the show cause notice is upheld. You would consider the cause shown by them and thereafter pass an order of termination. Then they would stand terminated. Until then, they're still in employment. Correct. So therefore, if the show cause notice is upheld, you will have to necessarily thereafter consider the cause shown and then pass an order of termination. Then they are dismissed from service. That has not been done in this case. Then implication, you are implying that because show cause notice is upheld, therefore you had the right to terminate him, and as a consequence, he does not get any benefit. That was also dismissed. It was also dismissed. They have gone in SLP, the matter is pending. So if the SLP is allowed, what happens? No, if the SLP is allowed, show cause notice will be quashed. They will continue in service. That is all that will happen. You know, they have this hyper-technicality by which they can get that money because you did not terminate them. No, you should have reserved liberty to yourselves, saying that I'm allowing you to attend age of superannuation. Therefore, I'm not passing any order now. It will be subject to the result of the writ petition. Then you got to pass some order. Wait till the Supreme Court decides. Why do you want to? Nah, if your termination, if your appointment is void, ಸೋತು ಗೆದ್ದಂಗ ಆಗತ್ತೆ ನೀವು ಸೋತು ಗೆದ್ದಂಗ ಆಗತ್ತೆ ವಾಟ್ ಇಸ್ ಎಷ್ಟು ಬರ್ಬೋದು ಕಾಸು ಅವ್ರಿಗೆ if your appointment is illegal, to now give you the benefit of
They are all fighting on the basis. It will be because we there are other certain roles that issue of common after the war. And later on also that has to be known. Now, below $80, they have regard for the service. And it will take that's very of the
ನಾವ್ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೆ ತಪ್ಪಾಗೋಯ್ತು ಅಲ್ವಾ? When is it posted? Do you have any idea? SLP? Well, after 4 weeks. 4 weeks. Let us see what will happen. SLP. There's already an order passed by this court. If I were to deviate from that order, I should have some good reason to deviate. This is the order that is passed. And in that view of the matter, list the matter up to 4 weeks. That this is what this court has said. They submit by the counsel appearing for the respondent that SLP have been filed against the order passed with this court in November so and so is pending consideration before the Supreme Court. That view of the matter. Now, ಅವ್ರು ಹೇಳೋದು ಇನ್ನೊಂದೇನು ಅಂದ್ರೆ ಅದು ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಇದೆ, therefore I can't do anything. If the SLP is dismissed, then where do you stand? He may have a point because you are not terminated. The stage was at the stage of issuing a show cause notice. That show cause notice is upheld. By the time that show cause notice fructified into a dismissal order, you had allowed him to retire. Therefore, that show cause notice has become. He's making me feel guilty. Therefore, because of you, we are suffering this. ಎಷ್ಟು ಜನ ಈ ತರ ಎಷ್ಟು ಜನ ಇದಾರೆ? ಒಟ್ಟು ಇಡೀ ಸ್ಟೇಟ್ ಬರುತ್ತಲ್ಲ ಕೊಟ್ಟೆಗಾರ ಕಮ್ಯುನಿಟಿ. There was a batch of petitions of this pending in Dharwad High Court. ಕೊಟ್ಟೆಗಾರ ಕಮ್ಯುನಿಟಿ ತಾನೆ? Because if I pass any order in one case, it will have in our because if I remember in Dharwad there were about 200 petitions pending, and in all those cases this problem will rise. Sections ಹಾಕಿದ್ರೆ ನೀವು released after 4 weeks. Released after 4 weeks on released on so and so. Counsel to inform the court as to the status of SLP 13484-88 by 2019, which is stated to be pending before the apex court. Hello. What is the next theory? Now this is only creation of posts. Annexary. 1 minute, 1 minute. Where you appointed? How many years have you worked? Where you appointed ಅಂತ ಹೇಳಿದ್ರೆ? This act does not contemplate what is to be done with the existing employees. No, the act, what does the act say? No. Does the act talk about employees? Section 9 ಇದೆಯಲ್ಲ. The government shall provide the authority with such officers and employees. What is the stand of the state here? No, they are the ones who are to take care of this, isn't it? Because under the provision. The government shall provide the authority with such officers and employees. No, the government shall provide the authority with such officers and employees as may be necessary. So they have no power of recruitment. It's only the government, whatever the government provides. No, Annexure C is only about a merger between you establish two entities. They appoint them on temporary basis. Then you come out with a statute, creating an authority, undertaking to provide employees. What should happen to them if they work for 10 years? Now it's rejected on the ground that it's not a sanctioned post. There was no entity at all at that point of time for a sanctioned post to be created. The sanctioned post came subsequent. Then what should happen to these people? There must be some transitory provision in respect of people who are working prior to the act coming into force, isn't it? Correct. There must be some provision in the act. It should meet their requirement also. Either tell them that they are not eligible or that they are eligible. Where should they go now? When you merge two entities and form one authority, what should happen to the employees? ವಿಲೀನಗೊಳಿಸುವುದು ಅಂತ ಅಂತಾರೆ. ಹೆಂಗ್ ವಿಲೀನಗೊಳಿಸೋದು? ಅವ್ರು ಟೆಂಪರರಿ ಆದ್ರೆ ಹೆಂಗೆ? ಅವಕ್ಕೆಲ್ಲ ಎಲ್ಲಿದೆ? ನಿಮ್ದಿನ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಫ್ರೇಮ್ ಮಾಡಿದಾರೆ ಏನಾದ್ರು ನಿಮ್ಗೆ? What should happen to the existing employees? No, but what will happen if you recruit these people? What will happen to them then? For how many years purely temporary? Now, from the date of the initial appointment, how many years have they worked? Second respondent authority ಬಂದೇ 10 ವರ್ಷ ಆಗಿಲ್ವಲ್ಲ ಇನ್ನು. Second respondent authority came into being in 2014. If they're working even prior to that. Because this annexure A that is the annexure A that is produced indicates that they've been working from 2009, 7, 10, 11. Annexure, correct, but for how many years? How will they be eligible now? If they put in 10, 15 years, they'll be age barred. See, in Umadevi's case, that argument of being appointed against a sanctioned post for regulation is one thing. Here, there was no entity at all at that point of time. ಮುಂಚೆ ಏನಾಗಬೇಕು, ಅವ್ರಲ್ಲಿ ಏನಾಗಬೇಕು? You should provide for regularization. ಅವ್ರೇನ್ seek ಮಾಡೋದು? ನೀವು ತಾನೇ ಅಪಾಯಿಂಟ್ ಮಾಡಿದವ್ರು. That is because the moment The moment you recruit them. Interim order ಇದೆಯಾ ಅಲ್ಲಿ? State to file its objections within a period of 2 weeks. Relist on so and so. If objection is not filed, the principal secretary, minor irrigation department to be personally present. The second respondent authority shall not relieve the petitioners from the post that they are presently holding without the specific leave of this court. No, ಅವ್ರು ತಾನೆ. No, all that I am saying, they will not relieve them without the orders of the court. Because he admits that they are working still. Even enter no, let us see what he will say. If he does not file, principal secretary should be present. Not 14, 17. ಇನ್ನು ಹೇಳಿದ್ದು. 14 to 14. 17.
Lordship, serial number 42, Lordship. I think second petitioner has expired. I appear for a respondent, Lordship.
Madam, one ನಿಮಿಷ.
Lordship, I have an submission.
Who appears for the petitioner? ನೀವ್ ಯಾರಿಗೆ?
ನಾವು 50ನೇ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ ಪೋಸ್ಟ್ ಲಂಚ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಅಲ್ಲ 44ನೇ ಮ್ಯಾಟರ್ ನಿಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ ನಮಗಿಲ್ಲ 50.
Relist on. ನಿಮಿಷ ನಿಮ್ 44 ಅಲ್ವಾ? Relist on so and so.
Lordship, serial number 42,
One
Lordship.
minute, madam, I'll come to you after I finish here.
Please, Lordship. Sorry.
ಎಲ್ಲಿದ್ದಾರೆ petition ಎಲ್ಲಿದ್ದಾರೆ? ಇಲ್ವಾ? Relist on. Yes, yes, madam.
Lordship, serial number 42, I appear for the first respondent. Second petitioner has expired, it seems, Lordship. I
Who's
will
for it?
ascertain, I pray for a short accommodation. I'll ascertain and make
Sir,
submission
sorry,
in this.
Relist on. Yes. No, madam, 2010. Come at 2:30, let us.
68.
Yes.
ಬರ್ಲಿ ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ಲ, why are you worried? Don't worry, I'll first hear him, then let us. So we're challenging annexure E. What is annexure E? Page number? Yellow. It's only in Gadag. Your first employer was independent employer, not connected with anybody. You sought for a stay of the order before the chancellor? The appeal that you have filed. But once you have preferred an appeal, challenging the very same order of transfer, it's obvious that you can't maintain the writ petition also. You have to choose one of the two. So there is a challenge of the same order before two authorities, one before the chancellor, one before this court. Which would you like to pursue? Then what should happen to that appeal? What is your C&R, which is the rules which govern your appointment? Institute of Animal Health and Veterinary Biologicals. Where is that? Page number? Where is the classification of the employees? Is it mentioned here? Where is that act which would merge all these institutes? Section 8 was the section. No. No, subsection 4 says every person employed by the US, Bangalore and US Dharwad, and serving in any of the colleges, research stations or institutions specified in subsection 1 shall, as far from the specified date, be transferred to the university on the same conditions of service as were applicable to him before such transfer, and continue to be governed by the same conditions of service unless and until such conditions are altered with the consent of such person. So this is a statutory transfer to the university, correct? Next, provided that no such person who is deputed from the state government to the US Bangalore and the University of US Dharwad shall be transferred to the university without the prior consent. This won't apply to you. You're not on deputation. Provided further that no person employed by the state government but working in colleges, research, so and so, the schedule shall be transferred to the university unless the state government. This also will not apply to you. Oh, because this is no person employed by the state government. So you are not employed by the state government. Correct. If you are a person employed by the state government but working in, so until you are employed in the state government, you cannot really take benefit of this proviso. Yes. This is an order of transfer, statutory transfer of every institution specified there. This is a notification by which you become a part of the university. No, the only thing that is guaranteed to you is your condition of service should not be altered without your consent. Now, what is the condition of service that is altered? Nothing has happened now. You're only transferred. No, I understand that argument, saying that you're not a teacher, therefore you can't be expected to teach. That is an argument I'll ask them. But apart from that, you have no other statutory right. But if you're a scientist, you should also be able to teach. It's not like as if it's some kind of your understanding of the subject will be the same. Maybe you're not an expert in articulating your thoughts, but you can definitely articulate your thoughts by becoming, what are you now transferred as? Not for you to question. Not for you to question. Not for you to question. An employee can't decide as to what is the exigencies of the employers. Is there any other organization for which you can be transferred to apart from this? You said there are several such institutions. Where? Where this post of scientistry is there any vacant post according to you? Without going into all the other arguments that he advanced, if he's working as a scientist, he was appointed as a scientist. From 2006 to 23, what was he working as? He was working in this particular institute. No, for the purpose of. Get about whatever he said. No. Kindly listen to me. Kindly listen to me first. He was appointed as a scientist from 2006 to 2023. Was he working as a teacher or was he working as a scientist? Forget about the equation. What was the actual discharge of work? Was it as a scientist or as? Forget about the nomenclature. What? Which college did he discharge? Is it a fact that you are discharging duties as a professor in a college? Can't you accommodate in some other laboratory?
Yes, you should take that. Yes, now in place under suspension. You are under suspension now.
I'm concerned about the fact that if he is not able to teach students for your problems, students should not suffer. If you send a person who has not taught in his entire career and now is to teach students for the first time, the real aggrieved parties will be the students, not the.
Exactly what you have to do. There is no one there. That is not the reason why you have to go. You have to go because there is a part of service and if they not, last time you didn't take it. So again, you out of the way. Nothing to say. No, accommodating. You have to be very.
Can you file an affidavit stating that he had worked and had taught students during this period after the amalgamation? File an affidavit. No, I'm concerned about what discharge of duties he did after the university was established till this order of transfer was made. If you are able to show that he was actually discharging functions as a teacher, then I'll uphold this. If he has not done, and if he has been working as a scientist in a laboratory as contained by, then I'll ask you to transfer him to a suitable post, not as a person who is to impart education to students in a college.
You want to make anything, I would request you want to make this paragraph of page 4. You cannot have it both ways. The wasn't any. Asking his friend, he state his friend and appeal to the governor. There's not a whisper about it in the petition. It is submitted in the year 2031, the petition had a complaint to the SCA.
You also seem to be more interested in fighting rather than in discharging your work.
You have to take anything. Intentional bias.
Let's not expand the scope of this petition. This is only a transfer order. I'll deal with it. I'll deal with it. The art of the matter is the order of transfer, isn't it?
We don't have it as inside, we got to meet that everyone. We find an activity. This very promotion, other career advancement.
Promotion. If she were to file an affidavit stating that you have discharged the functions of teaching at some point of time in the past 10 years, this order of transfer will stand confirmed. Only if she were to file an affidavit saying that you have never imparted education to students in a college, then you have a chance. Your salary will not get reduced whether you teach to undergraduate or to postgraduate students. Your job is to teach. If you are capable of teaching, teach. It's unfortunate that academics are more interested in this ego clashes rather than discharging their work. And I'm not confining this remark only to you, to both sides. Your job is to teach. Apart from teaching, you're doing everything else.
Every authority, earlier it was earlier was
Stop it. I know from this I can dismiss your petition only on the ground that you preferred an appeal without going into all that. So he should realize that he's hanging on a thin line. My only concern is the student should not suffer because of your ego clashes. Your rejoinder is like 3 times that of your writ petition. You need to indicate that you are more interested in fighting rather than teaching. Which do you want me to see? Page number? In what way are you concerned as to where she is posted, where she is not posted? You are acting as if you are the vice chancellor. Like you know how to run the university better than the vice chancellor. When they call for applications, make an application. Maybe you will be appointed the vice chancellor. File an affidavit, Vaishnavi. File an affidavit. If you can indicate in the affidavit that, but if he has not worked in college, then I will, you file an affidavit. You file an affidavit. When do you want it? Next Monday? Monday.
Methods. Number 1, anyone for me? Okay.
Lecture. Page number, is where is your serial number? Serial number 11 is Santosh Kurbet. 12 is Srinath Babu. Next page, serial number 13, 14 is. Okay. Date ಹಾಕಿದ್ರೆ ಯಾರು? Copy sir ಮಾಡಿದ್ದೀರಾ? I'll have it tomorrow, sir, the copy on amendment. Tomorrow. What is the next area? What is your name? Irish Babu. Govindraju ಅಂತ ಇದೆ. Next. No, you're challenging annexure A. What is annexure A say? Yes. On promotion. On promotion. If somebody is promoted, you will have to make way for them. No, you have not been given any posting. How are you asserting that there is a premature transfer? You have not been transferred yet. Correct. ನಿಮಗೆಲ್ಲೂ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಲ್ವಲ್ಲ, ನಿಮ್ ಜಾಗ ಯಾರು ಹಾಕಿದ್ದಾರೆ, ನಿಮ್ಗೇನು ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ಟಿಲ್ವಲ್ಲ. ನೋಡೋಣ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ. ಇವಾಗ ಗೊತ್ತಿಲ್ವಾ, ನಿಮ್ ಅಲ್ಲೇ ಇಟ್ಕೋಬೋದಲ್ಲ ಬೇರೆ ಜಾಗ ಕೊಟ್ಟು. Isn't it? Take notice. AGA to take notice for respondents 1 to 3. Notice to R4 is deferred for the present. When do you want it? ಅವ್ರು ಕೇಳ, ಅವ್ರು ಒಂದಿನ ಹೇಳಿದ್ರೆ ಏನಾಗತ್ತೆ ಏನೂ ಆಗಲ್ಲ. I will still have the power to. ನಿಮ್ಮನ್ನೇನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಲ್ಲ ನಿಮ್ನ ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕೆ. He may occupy your post, but you may be given a posting in the very same place. We don't know. Let us see what they will do. ಅಲ್ಲಿ ಬೇರೆ ಪೋಸ್ಟ್ ಇದ್ರೆ ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿ ಅವ್ರ ಫಸ್ಟ್. When do you want it? I have it on Wednesday. Wednesday. ಕೊಡಿ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ. Wednesday. I will reject the interim prayer. If you wait till Wednesday, I'll see what happens. If now some matter, I will say. ಏನ್ ಆಗೋಗಲ್ಲ. If that order of promotion is set aside or modified, you will still be able to occupy that post. Why are you worried? Until an order of posting is made, you don't have a. ನಿಮಗೆ ಇನ್ನೊಂದು subsequent order ಆಗೋರು ನೀವು writ petition premature. Let us see. Wednesday. Who's opposing you? ಮಿತಿ ಕೇಂದ್ರ ಒಬ್ಬರೇನಾ? ಇದೆಯಾ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ ನಿಮ್ಗೆ? What is the next series? ನಿಮ್ಮ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ನಿಮ್ದು ಕಾಂಟ್ರಾಕ್ಚುಯಲ್ ಏನ್ ನಿಮ್ದು? ಏನಾಯ್ತು ಈ ರಿಟ್ ಏನಾಯ್ತು? What happened to this? Into the show cause notice, now you have passed an order. Where is the order? In your position, can you dismiss an employee like this? ಎಲ್ಲಿ ಅಲ್ಲ ನೋಡಿ, ಈ ಸಂಬಂಧ ಸಮಿತಿಯ ತನಿಖಾ ಸದಸ್ಯರು ತನಿಖೆಯನ್ನು ಕೈಗೊಂಡು ವಿಸ್ತೃತವಾದ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ಸಲ್ಲಿಸಲಾದ ವರದಿಯನ್ನು ಕುಲಂಕುಷವಾಗಿ ಗಮನಿಸಿ ಪರಿಶೀಲಿಸಲಾಗಿರುತ್ತದೆ. ಯಾರು ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರು? ಅವ್ರದೇನು ನೋಟಿಸ್ ಇತ್ತ? ಏನಿತ್ತು? ನೋಡಿ, ಎನ್ಕ್ವೈರಿ ಅಂದ್ರೆ ನಾಟ್ ಯೂನಿಲಾಟರಲ್ ಎನ್ಕ್ವೈರಿ. ಶೋಕಾಸ್ ನೋಟಿಸ್ ರಿಪ್ಲೈ ಕೊಟ್ಟಾದ್ಮೇಲೆ it appears that some report was called for. Did you furnish this copy of this report to him? ಏನಾಗಿದೆ ನಿಮ್ದು? What has happened? Day after tomorrow. Where is your order of appointment as a project in the first place? Otsala reputation ಬರ್ದಿದ್ದಾರೆ. It is not very clear as to what is the terms of your employment, who appointed you. Regular employment ಇದ್ದಂಗಿಲ್ಲ ಇದು. Why can't you show me the appointment order? Who appointed you? Advertisement ಆಗಿತ್ತ, notification. Witnessed. ಬರ್ತಿದ್ದಾರಾ? Who's taking care of his cases? ನಿಮ್ಗೆ ಅಲೋ ಮಾಡ್ಬೋದು, ಅವ್ರು ಇಲ್ದಿರಾನೆ? ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ ಪೆನ್ಷನ್ ಬೆನಿಫಿಟ್ಸ್? ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ರು? No, the first appointment annexure does not indicate that it is any temporary appointment of 6 months. Now come to annexure B. Come to annexure B first. 84 was initial appointment for a period of 6 months. Now he was continued. Then in the year 1993. Now ನೋಡಿ, annexure B ನೋಡಿ ರಮೇಶ್, ಆತರ ಬರ್ದಂಗಿಲ್ಲ. Raja Reddy working temporarily as junior assistant in NAP unit, Bangalore to Bangalore, is extended the equivalent revised pay scale of the post of junior assistant. So now if this extension of pay scale is until further orders, After 10 years of. He has worked for how many years now? 84 to? When did he attain the age of superannuation? He is there in the seniority list also. Next sheriff. ಆತರ ಬರ್ದಿಲ್ವಲ್ಲ ಎಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ ಆತರ ಮತ್ತೆ if you have a seniority list in which his name is included, it doesn't look like ನೋಡಿ ಅದು ರೆಗ್ಯುಲರ್ ಅಂತಾನೆ ಇದೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ನೋಡಿ ಪೇಜ್ ನಂಬರ್ 34 ನಂಬರ್ 80 ಶ್ರೀನಿವಾಸಕ್ಕೆ ರೆಗ್ಯುಲರ್ ಎಲ್ಲ ಡು ಇದೊಂದು ರೆಗ್ಯುಲರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಂತಾನೆ ಬರ್ದಿದ್ದೀರಾ. How can you know say it's appointment against a project? This is regular appointment. This is also a record against you. But even if there's such a record, if the seniority list indicates his appointment is regular, then ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ರೆ ಸ್ಯಾಂಕ್ಷನ್ ಎಸ್ ಪ್ರೊಡ್ಯೂಸ್ annexure K, L and M. Once you indicate that he is a regular employee, the seniority list, I don't think you will be able to say afterwards that is only. He has worked from 84 till 2008. ಎಷ್ಟು ವರ್ಷ 24 ವರ್ಷ ಕೆಲಸ ಮಾಡ್ಬಿಟ್ಟು ಏನು ಕೊಡಲ್ಲ ಅಂದ್ರೆ if that project can survive for 24 years, if a project ಅಂದ್ರೆ if that project was there for 24 years, then he is a regular employee. Project ಅಂದ್ರೆ ಏನೋ 1 ವರ್ಷ 5 ವರ್ಷ 10 ವರ್ಷ 27 ವರ್ಷ is like one service tenure. Now, in which document do you say that as soon as the project is over, his employment comes to an end? ಕೊಡಬೇಕಾಗತ್ತೆ ನೀವೇನು 24 ವರ್ಷ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಮಂಡೇ. Find out if somebody else is appearing on behalf of an estimate. Is the matter about? For the petitioner, what is the order that is impugned? P&L. Your senior counsel for me, you just argue. You by yourself is a senior counsel for me, you argue. Annexure K. No, this is a 2010 matter, therefore I'm. What is Annexure K? Page number? Next hearing is the appellate order. The charges against you are pretty simple, saying that you being in the legal department, you collected certified copies of documents in respect of mortgage of deposit by title deeds. Finally, next time if you don't come, I'll pass orders.
Lordship, matter 50, please.
Matter 50, your lordship.
50.
50.
Yes.
This is I am for the respondent. The Ballard has to be argued. I have also filed a counter one because my while allowing the reinstatement is only 25% of the allowed for the back wages, 75% is rejected. As per the exhibit P19.
In ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀರಿ ನೀವು?
Teacher. Exhibit P18 is a dairy. P18A is the relevant entries. After the reinstatement, as per the exhibit P19, I issued a three months notice. They have accepted relieved. 2011. Till the date, I have to only back wages. That is only subsequent prior event. petitioner has to say whether I have resigned or not, as per the Exhibit P19. Para
Yes,
80.
vice- For 40 years in 2004.
ಹೌದು.
You must be what now?
Yes.
Almost 60 years.
Yes, 60 ಆಗಿಲ್ಲ 58 59
ಕೆಲಸ ಮಾಡ್ತೀರಲ್ಲ ರಿಸೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ರಿಸೈನ್ ಮಾಡಿದೀವಿ. 2011 ಅಲ್ಲಿ ರಿಸೈನ್ ಮಾಡಿದೀವಿ ಆಸ್ ಪರ್ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಎಕ್ಸಿಬಿಟ್ P19. ಇದು ಪ್ಯಾರಾ 8 ಆಫ್ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್. ಪ್ಯಾರಾ 8 ಆಫ್ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಫ್ ಸರ್ವಿಸ್ 3 months ನೋಟಿಸ್ ಕೊಟ್ಟು ಅವ್ರು ರಿಲೀವ್ ಮಾಡಿಬಿಟ್ರು ನಮ್ಮನ್ನ.
ಅದೇ ಯಾವ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ನೀವು ಆಚೆ ಕಡೆ ಇದ್ದಿದ್ದು?
2011 ವರೆಗೆ ಆಚೆ ಕಡೆ ಇದ್ದೀವಿ. 2004 ಇಂದ 96 ನಮಗೆ ಇದಾಗಿರೋದು. 6596 ಡೇಟ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್. 1,800 rupees salary. It is increased up to 12,000. Because the allegation was the teachers are the demand not taught properly. Showcase notice issue ಮಾಡಿದ್ದಾರೆ 2004 ನಲ್ಲಿ. No enquiry being held till now.
My lords, may I make a kind submission, my lords?
Yes.
My lords, can it please be had on day after tomorrow, my lords?
2010 matter, madam.
Yes, my lords, but senior is not keeping well, so day after tomorrow itself it may be had, my lords.
We don't come on Thursday, I'll decide it in your absence.
Please, my lords, please.
No, till the date that the resignation accepted, let them produce the letter.
Find out if she's still in service. Madam,
Yes, my lords.
find out if she's still in service, the petitioner is still in service.
Please, my lords, please.
Two 2011 country, ಸುಮ್ಮನೆ ಬಂದು ಟೈಮ್ ಕೇಳಿದ್ರೆ ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು? What is the next area? ಏನ್ ನಿಮ್ದೇನ್ ಕಂಡಕ್ಷನ್ ಏನು? This is a 2011 recruitment notification that you're challenging. 12 ವರ್ಷ ಹೋಗಿದೆ, ಇವಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ? ಏನ್ ಬೇಡ ಬಿಡಿ. Copies to the respondent. Objections ಹಾಕಿದಾರಾ? ರೆಸಲ್ಯೂಷನ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ರಲ್ರಿ? ಇಲ್ಲ ರೆಸಲ್ಯೂಷನ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ರೆ ಪರ್ಮನೆಂಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಹೇಳ್ತಾರೆ. ನಾಳೆಗೆ ಹಾಕೊಳ್ತೀನಿ, ನಾಳೆ ಬಗ್ಗೆ ಬನ್ನಿ. Thursday. What is the order that is challenged? Gina. Next year G. In charge, no? He was an assistant manager, huh? ಬರ್ತಾರ ಅವರು? ಚಂದ್ರಚೂಡ, ಅಮಿತ್ ಕುಮಾರ. Dismissal non-prosecution or application ಹಾಕಿದ್ರೆ allow ಮಾಡಿ. Not yours. ನೋಡಿದಿರಾ? ಇದೊಂಥರ this kind of you admit you approve the admission but deny the pension benefits. Correct. Come to page 50, page 50. Paragraph 5. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀ ಗೀತಾ ಅವರು ತಾನೇ ಪಿಟಿಷನರ್ ಅಲ್ಲ, ಅಮ್ಮಕ್ಕ ಇಸ್ ದ ಪಿಟಿಷನರ್. ಓದಿ ಪ್ಯಾರಾ 5 ಓದಿ. How many years has she rendered service? ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ರು ಅವರು? Then for the 13 or 14 years of service that she has rendered, ಇನ್ನು ಜಾಸ್ತಿ 20 years of service now is gone in one. ತಪ್ಪಾಗತ್ತಲ್ವಾ? Previous service if you don't take into consideration at all for the purpose of pension, pension ಬರ್ದ ಅವ್ರಿಗೆ. Objections ಹಾಕಿದಿರಾ? List. ಬರ್ತಾರ ಅವರು? ಏನ್ ಪೇ ಮಾಡ್ತೀನಿ ನೋಡೋಣ, ಆಮೇಲೆ ಬಂದ್ರೆ ನೋಡೋಣ. Why did you retire him compulsorily? ಇಲ್ಲ ಕೊಟ್ಟು ಬಿಟ್ಟಿದ್ದಾರೆ. Did he have the benefit of an interim order? ಆಯ್ತಲ್ಲ ಗೆದ್ಬಿಟ್ರಲ್ಲ ನೀವು. I'll record a statement and close. The petitioner is calling in question an order by which he was compulsory retired. The first respondent has filed a memo in which it is indicated that the petitioner was permitted to continue in service by virtue of an interim order that has been passed in this writ petition on he also submits that in the pendency of this writ petition, the petitioner was permitted to retire on attaining the age of superannuation, and he has also been paid all the benefits. In view of the above, the prayer and the writ petition will not serve for consideration, and the same is accordingly dismissed. Correspondent. Is the next race? ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದಾರೆ ಅವರು? But the work board has passed the order. ಏನ್ರಿ ನೀವು 2015 you are not appearing, not working. I will record a statement and close the petition. ಏನಕ್ಕೆ? I will record a statement. The petitioner is calling in question an order by which his services were terminated by the administrator. Senate Counsel Shri Mali Patil has filed an affidavit of Shri Abdul Rahman, the principal of the second respondent institution, in which it is stated that the petitioner was granted an interim order in this writ petition, and in the base of the said interim order, he worked till 30th of April 2015, and thereafter he has not worked in the college as an SDA and has not discharged any work. In view of the fact that the respondent has stopped working from April of 2015, it is obvious that the petition will not survive for consideration. Petition is therefore dismissed as being unnecessary. In your favor or against you? In your favor or against you? ನೋಡಿದ್ದೀರಾ? follow this judgment, the petitioner is calling in question factors LM and N L2 over. Whereby the claim of the petitioner for fixation of pay scale has been refused. The Learned Counsel for the petitioner submit to the division bench of this court in WP 45154/2017 as in identical cases, direct the state government to extend the benefit accorded to similarly placed persons in view of the judgment delivered by this court. It is in WP 32764-32770/1994. In view of the order passed by division bench, the prayer sought for the petitioner is required to be granted. The implement orders are quashed and the government is directed to extend the benefit of pay scale as has been ordered in WP number 32764-32770/1994 to the petitioner within a period of 8 weeks from the date of receipt of a copy of this order.
Bill number 58. Sir, proceed.
Antipushon, ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಫುಡ್ ಕಾರ್ಪೊರೇಷನ್ ಆಫ್ ಇಂಡಿಯಾಗೆ? Imports to the Anganwadi helper. ಇನ್ನು ಇದೆಯಾ ಇಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ 2011 whose appointment are you challenging? You are appearing for the third respondent. ಏನ್ ತಪ್ಪಾಗಿದೆ? ನಿಮ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಂತ ಹೇಳುತ್ತೆ? Where is the order? Where is the order that you are challenging? What is annexure M? ಯಾವ ಅಂಗನವಾಡಿ? ಯಾವ ಅಂಗನವಾಡಿ ಇದು? ಅದ್ನೋಡ. ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು ಇದರಲ್ಲಿ? ಪೇಜ್ ನಂಬರ್ annexure M ಅಲ್ಲಿ? ಪೇಜ್ 43 ಇರ್ಬೇಕು. ಓದಿ ಅದನ್ನು. 13. ದಿನಾಂಕ 5/7/2011 ಪೇಜ್ 43. She has secured more than you. ಫೇಲ್ ಆಗಿದ್ರ ನೀವು? ಫೇಲ್ ಆಗಿದ್ರ? ಫೇಲ್ ಆಗಿದ್ರ? Annexure R1 indicates that you are not a resident of that village, ತಾನೆ? Annexure R1 is the report which is produced, which indicates that you are not a resident of that particular village. ಬಿಡಿ. What is annexure R1? The same order? It indicates you are not a resident of that particular village. Adnor. But what does your domicile certificate say? Where is the certificate issued? What was the objections raised by them? Where is the objections raised by you? Page number? Mixture? Yes. Your husband is resident of some other village. Aparnal. ಬೇಡ ಬಿಡಿ ಅವ್ರ 10 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ ಕ್ಲೋಸ್ ಮಾಡೋಣ. Where is that SLC fail? ನಿಮ್ದೆಲ್ಲಿ? She has passed ಅಲ್ವಾ? Next sir. Dinamma. The petitioner is calling in question the appointment of the third respondent as Anganwadi worker. It is a case of the petitioner that the authorities, after verification of the records, had selected her provisionally and also published a list in that regard. It is her case that thereafter the third respondent raised objections contending that the petitioner was not a resident of Adanur village where the post of Anganwadi was located. The Tahsildar was directed to conduct an inquiry, and a report was thereafter produced indicating that the petitioner was not a resident of Adnur village and her husband was in fact a resident of ಯಾವ village ಅದು? Personally. It was therefore concluded that the petitioner was not eligible for being appointed as an Anganwadi worker. It may also be pertinent to state here that assuming that the petitioner was a resident of Adnur village, the fact remains that she only possesses an education qualification of having failed in SSLC exam, whereas the fourth respondent has passed SSLC as indicated in Annex N, which is produced with the petitioner herself. In view of the fact that the third respondent has more educational qualifications, assuming that the petitioner is in fact a resident of Adur village, she would nevertheless be entitled to challenge the appointment of the third respondent who is more meritorious. I find no reason to amend the petition.
Correspondent. Nandesh Pati.
My lord, serial number 61, my lord.
Yes.
My lord, I appear for the petitioner, my lord. My lord, the petitioner, my lord, was appointed as a Shirastadar at my lord, additional civil judge and JMFC Hospital, Ballari.
Who's opposing you?
My lord, Mr. Madhukar Deshpande is opposing.
Ready na? ನಾಳೆಗೆ ಬೇಕಂತೆ ಅವ್ರಿಗೆ.
My lord, could it be on Wednesday, my lord? I'll appear physically also.
Wednesday, I think, is only, there's a reference.
Then Thursday, please, my lord.
Thursday.
Thursday or Friday, please. Obliged.
Accepting his application. Why are there two petitioners? What is that scheme? Remember? Then read the further. When did you make the application for retiring voluntarily? When was the application given? When was the application given? Where is the order? Where is the order accepting your voluntary retirement? When was the application made by him? No, but if he had made his application, when he was between that 45 to 50. Yavat madre. If you have made the application in that window, 47 to 54 years, I will ask him to consider it without reference to the age on which you are permitted to retire voluntarily. Because the day you give the application is not accepted immediately. So therefore, if when you made the application, when is the application given by you? You should know when you gave the application. But for you to attract that scheme, you should be within that age group, isn't it? He also has a point. If you adopt that particular scheme and then grant him permission to retire voluntarily, you should get the benefits of that scheme. How can you exclude that? Then you shouldn't have allowed them to retire voluntarily under that scheme. Your enter next area refers to that particular scheme of yours. They will respond tomorrow by rejecting your claim. You want me to direct them to respond? That's what he's saying. They will consider and reject it now. Then you have to file one more petition, wait till 2033 for it to come up for hearing. I will hold that since you have permitted to retire in the light of the 2006 scheme, you are bound to consider it notwithstanding his age. Even otherwise also, since an annexure A, you permit him to retire only because of that scheme, you will consider it without reference to that particular age. You should not have allowed him to retire at all. When it was alive, then you should have given it to him. Find out when exactly he gave that application. Find out when exactly the application is given. Released on. Next Monday. Matter, Sadish. Team manager. What are the charges against you? The enquiry report. There are 5 charges against you. So 4 is proved. Article 4 is proved. Charge 4. That charge number 4 by itself is sufficient, isn't it? You have not collected PDCs. ಕಮ್ಮಿನೇ ಆಯ್ತಲ್ವ ನಿಮ್ಗೆ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಅಲ್ವ ಇಷ್ಟು ಅಮೌಂಟ್ ನೋಡಿದ್ರೆ ಯು ಹ್ಯಾವ್ ಬೀನ್ ಗಿಫ್ಟೆಡ್ ವಿತ್ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಡಿಸ್ಪೈಟ್ ದಿಸ್. ಇಲ್ಲ ಬಟ್ ಒಂದು ಪ್ರೂವ್ ಆಗಿದೆಯಲ್ಲ, ದಟ್ ಬೈ ಇಟ್ಸೆಲ್ಫ್ ಇಸ್ ಸಫಿಷಿಯಂಟ್ isn't it? ಓದಿ ಅದನ್ನ. Page 65. This particular act of getting PDCs was exclusively yours. What was your job then? Deputy manager. ಅವ್ರಿಗೆಲ್ಲ ಏನ್ ಮಾಡಿದಾರೆ, ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಏನೋ ಮಾಡಿದಾರಲ್ಲ. Page 97 ಬನ್ನಿ. Page 97. Major penalty on Devraj Gowda, ex-GM, KL Anand, allegation, Prabhu, Dubey, Lakshmipati, Jagannatha, Ravindran and MB Ninjagowda. ಎಲ್ಲರಿಗೂ ಮಾಡಿದಾರಲ್ಲ. ಆಯ್ತಲ್ಲ, ಮೇಜರ್ ಚಾರ್ಜ್ ಅಪ್ರೂವ್ ಆಗಿದೆ. It's not like as if you have been exonerated. You have got the benefit of compensation. What have you lost? ಆ ಸರ್ವಿಸ್ ಅಂತ ಹೋಯ್ತಲ್ಲ ಈಗ. Then what is the point? The department inquiry against the petitioner, his petitioner was initiated. 5 articles of charges were leveled against him, out of which the inquiry officer found that article 1, 2 and 4 were partly proved and article 3 was not proved. The inquiry officer, however, concluded that article 4 was proved. Next. Article 4, which was leveled against the petitioner, was as follows. Is number 3.4. The finding recorded by the inquiry officer on article 4 reads as follows. This inquiry report was considered by the disciplinary authority after issuing a show cause notice to the petitioner. The disciplinary authority accepted the said inquiry report and imposed a penalty of compulsory retirement. A second stage advice was thereafter obtained from the Central Vigilance Commission, which also was of the view that a major penalty was required to be imposed on the petitioner. Accordingly, the major penalty of compulsory retirement was imposed against the petitioner. As against this imposition of the major penalty of compulsory retirement, the present petition has been filed. When counsel for the petitioner strenuously contended that the entire procedure by which charge number 4 was held to be proved against the petitioner was incorrect, since the since a joint inquiry was not conducted in respect of all the officials who were responsible for the alleged wrongdoing, he submitted that the charges leveled against the petitioner could not be attributed to his individual discharge of work, and the said charge would necessarily have to be laid against all the employees. As could be seen from the Article 4, the primary responsibility of collecting the post-dated checks were essentially on the petitioner, and the petitioner has admittedly not discharged the said obligation, which has resulted in serious exposure of financial loss to his employer. Having regard to these facts, in my view, the employer was justified in imposing penalty of compulsory retirement. I find no grounds to interfere with the punishment imposed, and I also do not find any irregularities in the conduct of the inquiry, which has seriously prejudiced the petitioner in any manner. The petition is therefore dismissed. ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ. ಏನ್ ಸಿಗುತ್ತೆ? He is already collected it. What is the second round that he'll get? No, the moment you are compensated, you will be given everything. If as a result of the imposition of compulsory retirement, the petitioner is entitled for any monetary benefits, and if the same is yet to be paid, the same shall be made over to his legal representative.
I'm for the petitioners, Mala.
Yes.
But Lashmi, kindly take up WP 56440 of 2014. Not matter relates to fixation of revision of pay, my lord.
Parties ಬಂದು ಏನ್ ಮಾಡ್ತಾರ? What is the settlement that is arrived at?
May I settle?
1 minute, 1 minute. ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿಲ್ವಲ್ಲ ನೀವು? Is it a fact, Mr. Bajantri?
No, my lord. Lord, may I submit, my lord? The benefit of revised CPC, which was sought to be given in 1/1/2006. Now, my lord, during the pendency of these writ petitions by a resolution in 2018, my lord, they sought to grant them prospectively, my lord. That is also under challenge before this honorable court by way of an amendment.
He is saying that your party has agreed for a settlement.
Lord, what they are forcing him to accept the settlement because of the age, my lord. He is 89 years old, and he is being threatened that in case even if you win the before the single judge will file an appeal. Lord, that is how they are threatening, my lord.
Lord, I appear for respondent 2 and 3 in this.
He is a lawyer. He shall I say that lawyer or instructions naan helakagata. If the lawyer is saying that he has not agreed, then I force the party to come and enter into that controversy.
Lord, I appear for respondent 2 and 3 in this. My Lord, I have
Yes.
recently entered appearance, my Lord. If I with Lordship permits, my Lord, a week's accommodation, my Lord, I'll get today and argue this matter.
Who
Lord,
are
for the
you?
institute, my Lord,
Who's
I am the
R2 and
employer,
R3?
my Lord. I am the employer, my Lord. This point number 2 and 3.
Clear, Gangare.
In WP 56439 of 2014 for the institute.
What is the grievance, Ms. Vajendri?
My Lord,
The grievance is, my Lord, the 6 CPC, my Lord, the benefit was not extended to them solely on the ground that they were not holding the designated posts. The Lordship may kindly see the impugned endorsement at page 38, my Lord, in 440, my Lord, 56440.
Annexure?
Annexure J, my Lord, page 38. Lord, he was working as a senior public relation officer as on the date of retirement. Lord, on the ground that the designation which he was holding, Lord, they cannot extend the benefit of the revised pay scale in terms of the government order. The Lordship may kindly see the last paragraph, Lord. The revision of pension in PB4, 37,400, 67,000 with GP 8,700 for pre-2006 non-teaching post cadre are made applicable only in respect of those who hold designation of the Deputy Registrar, Deputy Finance Controller, Deputy Controller of Examination subject to completion of 5 years of service in pre-revised scale of 3,700 and 12,800 as applicable prior to 1/1/2006.
What was the pay scale that you were holding?
I was holding the 12,800 and 12,000 and 18,300 as on 1/1/88 itself.
Is it a fact, Mr.
my Lord, in fact, my Lord, the government order based on which, my Lord, the petitioner is seeking, my Lord, pay scale revision, my Lord, applies only to those who have retired prior to 1/1/2006. In fact, my Lord, the preamble to that order, Annexure F, my Lord, page 31. My
No,
Lord,
please read
WP
Annexure J with
56439.
you. Annexure J.
My Lord, I only appear in 56439 of 2014, my Lord.
No appears in
endorsement has been
5640.
issued till date, my Lord. In that case, my Lord, no endorsement has been issued till date. I am only seeking for a direction there, my Lord. In that writ petition, such an endorsement has not been issued, but he is also been denied the very same benefit. But my Lord, the Government of India order, my Lord, also doesn't say the designations what the Government of India says. My Lord, that I have produced at page 27. Your Lordship may kindly see, my Lord.
Who
In fact,
appears for the institute in this 56440? Padubidri Mohan. Idhar avru?
Lord, he had appeared earlier, my Lord. From his office, some other person was appearing, my Lord, on earlier occasions. Also, they have filed the objection statement also.
In fact, that's the reason, my Lord, I'll point out these things. My Lords could have it next week. My Lord, I'll bring out, in fact, my Lord, statement of objections are already filed. My Lord, two points. One, my Lord, that these rules apply, these revision applies only to those who have retired prior to 2006. Secondly, my Lord, the petitioners retired in their maximum pay scales. My Lord, their terminal pay scales, they have retired. There is no need.
Annexure J, last paragraph says, the revision of pension in pay band 4, that is 37,400 to 67,000 with grade pay of 8,700 for pre-2006 non-teaching cadres are made applicable only in respect of those who hold the designation of Deputy Registrar, Deputy Financial Controller, Deputy Controller, subject to completion of 5 years of service in the pre-revised scale, rupees 3,700 to 5,700 and rupees 12,000 to 18,300. So if he was holding this pay scale prior to 2006.
My Lord, but they admittedly do not fall under any of these categories. My Lord,
Yes,
petitioners were.
I have been extending that benefit, page 15.
Petitioner, my Lord, in WP 54649, if your Lordship sees petitioner retired, my Lord,
Same
as
petitioner,
assistant editor.
Same petitioner.
Lord, page 15, my Lord. Kindly see the pay scales that are extended to me. I have given the dates also, my lord. Page 15, serial number 2, H.S. Nagaraj.
Lord, he retired as assistant editor. In the
What
same
was
scale
his
of
pay scale that he was holding?
My lord, that I have shown along with the statement in the page 15, my lord. My lord, as on the date, my lord, 1988, my lord, he was in the scale of 3,700, 5,700. That is equivalent to 12,000 and 300. As on, my lord, he has completed more than 5 years prior to 2006. In fact, 1196 itself, he has completed 7 years, my lord, because that was extended on 1988. Page 15, my lord. 3,700 and 5,700. That is equivalent to, my lord, 2006 scale of 12,000 and 18,300.
Yes.
My lord, he was placed in the scale of 3,700 with
On
effect from
1/1/2006.
Yes,
On
my lord.
1/1/2006, he was in the pay scale of 15,600.
No, my lord.
13,100 plus grade pay of 7,600.
No, my lord, he
as
was
per
in the pay
Annexure
scale
A.
of 12,000, my lord. He was
No, he is
as
referring
stated
to
in
the
my
other
statement of
restriction,
objections
my
only,
lord.
my lord.
He
That
is
is on
referring to
1190. That is on 1196.
No, my
That
lord.
is on 1/1/2006.
No, my lord. 1196, my lord, that I've stated in my statement of objections, if your lordship takes, my lord, para 3 is when I have stated when he joined, my lord.
No, even if you assume that he was carrying
Please,
that
my lord.
12,800, 12,000 to 13,000, 18,300.
Yes.
Even according to this, prior to 1/1/1996, he was considered
Yes.
in that pay scale only.
My lord, but the pay scale in which he
1/1/1996.
retired, if your lordship sees, he was placed in, my lord, in 2006, 7,600.
No, that is the grade pay.
Grade pay.
Mikid node.
That grade pay was, in fact, in, my lord, 37,400 and 67,000. Now, your lordship may kindly see the
My lord, I
resolution.
will-
Passed
Your
out.
lordship may permit me time till
Asking
next
for
week, my
time,
lord.
so
I'll
I don't
verify it
want-
because, my lord, I've not obtained proper instruction. My lord, I've entered appearance recently. I filed Wakalatnama, my lord. It's hardly been a week. I'll get instruction. Your lordship may have it next week. I'll get ready and out.
Next Monday. ಕೇಳಿ ಭಜಂತ್ರಿ ಅವರೇ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಕೇಳಿ
ಇಲ್ಲ, Swami, what they are forcing him to accept their this one, my lord. They have taken passed a resolution in 2018 extending this benefit to them prospectively. When I am fighting here, my lord, from that I am entitled from 1/1/2006.
I have a copy of that resolution.
Yes, I have enclosed along with the petition. The lordship may kindly see WP.
Get instructions on that also.
Please, my lord, please.
Lord, 56439 I have produced along with the amended application.
All right, next week thought. Who's opposing?
It will come up on next Monday, my lord.
Yes, next Monday.
Please.
Waiting for the respondent in this matter, my lord. Short accommodation bill.
Yes, short. ನಾಳೆನಾ?
ನಾಡಿದ್ದು.
ನಾಳಿದ್ ಬೇಡ, Thursday.
Please, man.
ನೀವು ಬರ್ತಿಲ್ವಂತೆ ಕೋರ್ಟ್ಗೆ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹಂಗೆ ಡಿಸೈಡ್ ಮಾಡ್ತೀನಿ.
ಬರ್ತಾ ಇದೀವಿ.
ಗುರುವಾರ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಬರ್ತೀನಿ. Yes, ಬರ್ತೀನಿ.
is opposing you. Clear. What is this condition number 2? Page number condition. Next year. Page extended page. Condition number 2 ಅಂತಲ್ಲ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ನೀವು. Conditioner number 2 in the GO dated 8/10/2012. Condition 2 ಅಂತ ಇದೆ. Now your prayer talks about irrespective of the condition number 2 in the GO dated 8/10/2012. Insofar as it is the first petitioner, condition number 2 in the GO dated so and so, but annexure insofar as it relates to second petitioner's concern. Second or third? Objections ಹಾಕಿದಾರಾ? File objection free list on, by which time the state government shall file its objections, carrying which the third respondent to be personally present. ಏನಾಯ್ತು ಅದಕ್ಕೆ? Yes. Number 69.
I appear for the petition, my lord.
Yes.
My lord, the petition, my lord, is working, my lord, as a constable, my lord, with the respondents. And my lord, she has given, my lord, annexure C and D, seeking, my lord, for voluntary retirement, my lord, from the services during January, my lord, 2020.
What is annexure A?
Annexure A, my lord, is the rejection of, my lord, my voluntary retirement application. Besides, my lord, directing me to get transferred, my lord, to ASG Mumbai, my lord. My lord, initially, my husband, my lord, who was in, my lord, BSF, he was on deputation to Bangalore, my lord, to CBI Bangalore. And I was also working in Bangalore. We have 2 kids, my lord, who are aged about 7 and 4 years. That is why an application was given to cancel the transfer. One of the spouses, my lord, that is the petitioner's husband, he was sent back, my lord, to Rajasthan, and the petitioner was permitted to be in Bangalore. And my lord, thereafter, my lord, her children, my lord, have been admitted to school. Now, my lord, she wants to get retired from the services during January. She has made an application, but with undertaking affidavit also. Despite the same, my lord, they are not considering it, my lord. Just 4 months time left. If they were to consider, if required, I'll file one more undertaking affidavit during January 2024. My lord, I'm ready.
Why was it rejected?
Similarly placed people, my lord, they have been permitted.
Where is the requisition? Advance voluntary retirement. When does she become entitled for voluntary retirement? How can you seek for retirement with effect from March 2025?
My lord, that is permitted, my lord, by the department. Similarly placed people, my lord, 1 year advance retirement they have given. I have 2 children, my lord, in the midst
it a
of
fact?
academic year.
What have you produced to show that similar cases has been accepted by the department?
Document I could not get, my lord, but they have provided, my lord. Now, my lord, in the midst of
Sir,
academic,
ಈಗಲೇ ತಗೊಳ್ರಿ. How can you dictate terms? I will retire from 2030. No, therefore,
that is permitted, my lord. If required, my lord, if my lord gives me 2-3 days time, my lord, I'll produce material, my lord. That's so.
they have sought for vacating the interim order. What interim order have you obtained?
Not to my lord, transfer, my lord. I am presently working, my lord, in Bangalore. Otherwise, my lord, I'll have to get shifted, my lord, to Mumbai airport, my lord. Except me, my lord, there are no one in the house. My husband is in Rajasthan. That's
ಇಲ್ಲ
why.
ಕಷ್ಟ ಇದ್ರೆ ಬಿಟ್ಬಿಡಿ. ಅದಕ್ಕೆ ನೀವು how can you impose conditions? ಇಂಥದ್ದಿಂದ ರಿಟೈರ್ ಆಗ್ತೀನಿ, ಅಂತದಿಂದ ರಿಟೈರ್ ಆಗ್ತೀನಿ, unless the rules
3-4
provide for
months
such
ಅಷ್ಟೇ
kind of.
ಕೇಳಿದ್ದೀನಿ. ಇನ್ನೊಂದು 3-4 months ಅಷ್ಟೇ ಕೇಳಿದ್ದೀನಿ. Next week I'll produce material, my lord. Next
4 months
Monday.
ಎಲ್ಲ ಆಗುತ್ತೆ.
Next Monday, my lord, it could be taken.
What is so auspicious about March 2025?
No,
Either
not,
way you want to go out of service, go out now, right now. Why do you want to wait till 2025?
my lord, there are 2 children.
ಜಾಸ್ತಿ ಬರುತ್ತಾ?
ಹೌದು, ಅದಕ್ಕೆ 2 ಮಕ್ಕಳಿದ್ದಾರೆ, ಓದ್ಸಕ್ಕೆ ಕಷ್ಟ ಆಗುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ಇನ್ಕ್ರಿಮೆಂಟ್ ಬಂದ್ರೆ ದೇ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು, my lord, ಸರ್ವೈವ್.
Then go to Bombay.
ಅಲ್ಲ, ಮಕ್ಕಳು ಬಿಟ್ಟು ಹೋಗಂಗಿಲ್ಲ, ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಎನಿವೆ, my lord, it could be taken up next Monday, my lord.
ಬೆನಿಫಿಟ್ ಸಿಗುತ್ತೆ ಅವ್ರಿಗೆ.
ಹೌದು, ಒಂದು ಇನ್ಕ್ರಿಮೆಂಟ್ ಸಿಗುತ್ತೆ.
I'll have it for orders Thursday. Top gip ಇಲ್ಲ. 2016 ಮ್ಯಾಟರ್ 23 ಮ್ಯಾಟರ್ ಟಾಪ್ ಅಪ್ ಬರಕ್ಕಾಗಲ್ಲ. ಹಿಯರಿಂಗ್ ಒನ್ ಐಎಗ್ ಹಾಕ್ತೀನಿ, ಅವಾಗ ರೀಚ್ ಆಗುತ್ತೆ.
My lord, next Monday, my lord, not Thursday, my lord.
Thursday,
By the
Thursday.
time I'll try and get the next Monday.
Court officer.